Welcome to HOA Busted. The board picked the wrong week to play games. I moved to St. Paul, Minnesota in early December because the school district offered me an assistant coaching job and the rent was lower than the Twin Cities core. The preserve at Frostwood HOA Incorporated sounded fine on paper, tight rules, but nothing I could not handle. Then the power went out during the first real blizzard of the season, and I fired up my generator so my fridge would not die. And that is when Christine Howard, the pool and amenities chair, showed up at my door at 7 in the morning holding a laminated policy sheet she refused to hand over and told me I will as creating a nuisance that violated winter emergency protocols. She said, "I am the reason this neighborhood stays civilized, and you need to shut that thing off right now or I am writing you up." I told her the power was out, and I needed the generator for food storage. She said the noise disturbed the aesthetic during a community hardship event and walked away before I could argue. 20 minutes later, I found a violation notice on a clipboard clipped to my mailbox post. No readable text but the board logo stamped at the top, and the fee listed was $250 if not resolved within 48 hours. I just moved in. I could not afford to lose the place or get dragged into court over a generator during a blackout. I shut it off, ate cereal for breakfast, and started looking up the actual rules. That is when I saw the small snow gauge stake planted in my front yard near the walkway, a little orange pole with measurement marks, and I realized Christine was already watching my property for snow accumulation before the storm even hit. The blizzard lasted 2 days. The plow came through on day 3 and shoved a ridge of hard-packed snow across the end of my driveway. I shoveled it clear by noon, piled the snow along the curb like the rules said, and went inside to thaw my hands. An hour later, Christine was back, this time with a stopwatch in one hand and a folding ruler in the other, measuring the height of my snow pile and timing how long the melt runoff took to drain into the street. She said my pile was 6 inches over the maximum allowed temporary accumulation, and the runoff was creating a slip hazard in the crosswalk. I asked where that rule was written. She pulled out the laminated sheet again, pointed to a block of fine print, and said it was all there if I cared to read instead of argue. I took a photo of the sheet from 3 feet away, could not make out a single word, and she smirked and said, "Make it public. I love watching people get embarrassed." That night, the neighborhood group chat lit up with a post from an anonymous account, photos of my driveway with the snow piles circled in red, and a caption that said negligent shoveling during storm conditions, resident refuses to follow emergency protocols, creating hazards for families and seniors. My name was not on it, but my house number was visible in one of the photos. People I had never met were commenting about irresponsible newcomers and wondering if the board should escalate. I messaged the group admin asking who posted it. No response. I messaged Christine directly on the platform. She replied within seconds and said the post was community contributed and reflected valid safety concerns, and if I had an issue I should address my behavior instead of deflecting. I screenshot the whole exchange and saved it. The next morning I woke up to find a second notice clipped to my car windshield, this one citing driveway snow storage violation. Failure to remediate within posted timeline. Additional fee $300 due within 72 hours or subject to lien filing. The car was in my own driveway. The notice had a board member signature stamp at the bottom. No name, just a badge clip with a blank face printed next to it. I called the management company listed on the HOA website. The woman who answered said Christine Howard handled all winter compliance and I would need to speak to her directly or attend the next board meeting. I said I wanted to file a formal complaint about the harassment and the fees. She said I could submit that in writing and the board would review it at their discretion, but in the meantime the fees were still owed and enforceable under the covenant. I hung up and called my friend Derek, who works in IT and has saved me more than once by verifying metadata and timestamps on sketchy emails. I told him what was happening and asked if he could look at the group chat post and the photos. He said send everything and he would see what he could pull. That afternoon, a contractor truck pulled up in front of my house. A guy in a reflective vest got out with a clipboard and knocked on my door. He said he was here to inspect my snow pile for code compliance and possibly remove it if it was deemed a safety risk. I asked who sent him. He said the HOA authorized the visit and he had a work order signed by Christine Howard. I asked to see the work order. He showed me a printed page with Christine's name typed at the bottom and the board logo, no readable signatures, and said he was just doing his job. I told him I did not consent to any work on my property, and if he touched my snow pile, I would call the police. He shrugged and said he would note my refusal and report it back to the board. He took photos of the pile from 4 angles, got back in his truck, and left. 10 minutes later, Christine texted me from a number I did not recognize. She said refusal to allow safety remediation was a separate violation under emergency powers granted to the board during winter storm conditions, and I was now facing an additional $500 expedited hearing fee and a mandatory compliance meeting scheduled for the following week during a storm day when travel was dangerous. She said the meeting was non-negotiable and failure to appear would result in automatic escalation to lien and collections. I screenshot the text and forwarded it to Derek. He called me back within the hour and said the group chat post metadata showed it was uploaded from an IP address that matched the HOA office network, and the timestamp was 30 minutes after Christine left my house the first time. He said the photos were taken with a phone that had location services enabled and the coordinates matched my street address. He sent me a PDF report with all the technical details and said it was enough to prove Christine posted it herself and lied about it being community contributed. I printed the report and started building a file. I had the screenshots of her texts, the photos of the notices, the work order from the contractor, and now proof she was running a smear campaign from the board office. I also had payment confirmations from my bank showing I paid my HOA dues on time every month since I moved in, despite the winter fee blast Christine sent claiming I was delinquent on snow removal assessments that did not exist in the original covenant I signed. The hearing was scheduled for the following Thursday, the same day the Weather Service was predicting another storm with ice and freezing fog. I emailed the board secretary asking if the meeting could be moved to a safer date. She replied and said the board operates on a fixed calendar and exemptions are not granted for weather unless the county declares a travel ban, which had not happened yet. I asked Derek if he could come with me as a witness. He said absolutely, and he would bring printouts of the metadata report in case they tried to dismiss it as hearsay. I also called a lawyer my cousin recommended, left a voicemail explaining the situation, and said I might need representation if this went to collections or lien filing. The lawyer called me back that evening. Her name was Angela, and she said HOA disputes were common in her practice, but the speed of Christine's escalation was a red flag. She said the fees sounded punitive, and the emergency powers language was questionable without a formal county or state declaration. She said if I wanted her to send a letter demanding a retraction and a refund, she could do that for a flat fee, and it might be enough to make them back off before the hearing. I said yes, do it, and she said she would have it drafted and sent by Monday. The next day I went out to shovel the fresh snow that fell overnight and found the small snow gauge stake moved to a new spot closer to my front step, repositioned so it would measure accumulation right where I walked most often. I pulled it out, took a photo, and stuck it in my garage. If Christine wanted to play games with props, I was going to keep the evidence. That weekend, I got an email from the management company saying a compliance review was scheduled for Monday morning, and a vendor would be on site to assess winter drainage and structural safety around my unit. I replied and said I did not authorize any inspections and I wanted written documentation of what legal authority they were claiming. No response. Monday morning the vendor showed up. Same reflective vest guy from before, and this time he had a second person with him carrying a camera and a tablet. I opened the door and said I already told you I do not consent to this. He said the board authorized the inspection under the covenant maintenance clause, and if I obstructed access, they would report it as a violation and pursue entry through the county if necessary. I said I wanted to see the signed authorization and proof that the covenant actually allowed unannounced inspections. He handed me a printed page, no readable signatures, just the board logo, and a typed paragraph claiming emergency maintenance access during winter hazard conditions. I took a photo and said I was documenting this entire interaction. He said that was fine, they were recording it too for liability purposes. They walked around the perimeter of my driveway, took more photos of the snow pile, the cleared walkway, and the area near my mailbox, then got back in the truck and left. An hour later, I got another text from Christine. She said the inspection found multiple safety deficiencies including improper snow storage, inadequate melt drainage, and unapproved use of a generator during a declared board emergency, and the total fines now stood at $1,200 payable immediately or subject to automatic lien filing within 10 business days. She said the hearing on Thursday was my last opportunity to resolve this without legal action, and I should bring payment or a written plan to remediate all violations. I called Angela and told her what just happened. She said she already sent the letter that morning via certified mail and email to the board president, the management company, and Christine Howard personally. The letter stated that the fines appeared to be unsupported by the recorded covenant. The inspections were conducted without proper notice or consent, and the smear campaign in the neighborhood chat constituted defamation and harassment. She demanded an immediate retraction of all fees, a public correction in the group chat, and a written apology, or I would pursue legal remedies including a restraining order and a claim for damages. She said the letter also cited the metadata report as evidence of board misconduct and noted that the county had no record of any declared winter emergency that would grant the board the powers Christine was claiming. She said if they ignored the letter or retaliated, we would file in court and seek an injunction to block the lien and force the board to follow proper procedures. I felt a little bit of relief for the first time in a week. I did not raise my voice, because my proof was louder than any argument. I had the timeline, the screenshots, the payment records, and now a lawyer on my side who was not afraid to call them out in writing. Tuesday morning, I got a call from the management company. The woman on the phone sounded nervous and said the board had received legal correspondence and they were reviewing it with their attorney. She said the hearing on Thursday was still scheduled, but the board wanted to offer me an opportunity to settle the matter informally before it escalated further. I asked what that meant. She said if I agreed to pay a reduced fine of $300 and signed a compliance agreement acknowledging the violations, the board would waive the rest and close the file. I said no. I told her I had proof the violations were fabricated, the fees were punitive, and Christine Howard was running a harassment campaign using board resources. I said I wanted a full retraction, a refund of any fees already assessed, and a public correction in the neighborhood chat, or I would see them in court. She said she would pass that along and ended the call. Wednesday the weather got worse. Freezing fog rolled in and made everything look haunted. Visibility dropped to almost nothing, and the roads turned into ice rinks. I got an email from the board secretary saying the hearing was still on for Thursday at 6 p.m. in the community clubhouse and attendance was mandatory. I replied and said the roads were dangerous and the county was advising against non-essential travel. She said the board considered HOA business essential and the hearing would proceed as scheduled. Derek texted me and said he could still make it if I needed him there, but his car did not have good tires and he was worried about sliding off the road. I told him to stay home, I would bring the printed reports myself and handle it. He said good luck and call me after, I want to know how it goes. Thursday afternoon I got a call from Angela. She said the board attorney had contacted her office and informed her that the board was declining to retract the fees or issue any public correction, and they intended to proceed with the hearing as scheduled. She said the attorney also claimed the board had full authority under the covenant to assess fees and conduct inspections, and my refusal to cooperate was grounds for further enforcement. Angela said she told him he was wrong, and if the board pursued the lien, she would file an emergency motion to block it and request a hearing on the validity of the fees. She said she also informed him that we had evidence of defamation and abuse of process, and we were prepared to bring counterclaims if this went to litigation. She said he did not respond well and ended the call, which suggested the board was not backing down. I asked her what I should do at the hearing. She said, "Go, bring all your documentation, do not admit to anything, and make them put their claims on the record." She said if they try to intimidate you or refuse to let you present evidence, document it and leave. She said we would file the motion on Friday regardless of what happened, but the hearing might give us additional evidence of their misconduct. I loaded my file into a folder, printed extra copies of everything, put on my brown winter jacket and navy knit beanie, grabbed my thermos mug steaming in the cold, and drove to the clubhouse. The roads were terrible, the freezing fog made it almost impossible to see, and I nearly slid through a stop sign on the way there. I parked in the lot and walked to the entrance, my boots crunching on the ice and packed snow. Inside the clubhouse, the heat was barely working and I could see my breath. The board was sitting at a long table in the front of the room, 5 people total, and Christine Howard was in the center wearing her white parka and gray knit hat even though we were indoors. She had the laminated policy sheet on the table in front of her and a stack of papers next to it. There were 2 other residents in the room, both sitting in the back row, and I recognized one of them as a board member who lived 3 streets over. He was pretending to be neutral, but he kept glancing at Christine like he was waiting for instructions. The board president, a man in his 60s with a gray beard, opened the meeting and said we were here to address multiple violations reported by the compliance chair regarding winter safety and noise nuisance at my address. He said I would have an opportunity to respond after the board presented their findings. Christine stood up and started reading from a printed statement. She said I had repeatedly violated emergency snow storage protocols, failed to remediate hazards in a timely manner, obstructed authorized inspections, and created a noise disturbance during a community hardship event by operating a generator without board approval. She said the total fines assessed were justified and necessary to maintain safety and order, and my refusal to pay or comply demonstrated a disregard for the community and the rules I agreed to when I moved in. She said the board had photographic evidence, inspector reports, and witness statements, and she recommended the board proceed with lien filing and collections unless I agreed to immediate payment and a signed compliance plan. She sat down and looked at me like she had already won. I stood up and said I had documentation that contradicted everything she just said. I opened my folder and pulled out the payment confirmations showing I was current on all dues and fees, the metadata report proving Christine posted the smear campaign herself, and the timeline showing the inspections were conducted without proper notice or legal authority. I said I also had a letter from my attorney demanding a retraction and a refund, and if the board proceeded with the lien, I would file a motion to block it and pursue counterclaims for defamation and abuse of process. Christine interrupted and said the board does not recognize unverified third-party reports as evidence, and my attorney had no standing to interfere with internal HOA business. I said the metadata report was verified by a licensed IT professional, and the timeline was based on the board's own notices and emails, all of which I had saved and printed. I said the board could ignore it if they wanted, but a judge would not. The board president said the board would take my submissions under advisement and issue a written decision within 10 business days. I said that was not good enough. The hearing was supposed to be my opportunity to respond and resolve this, and if the board was just going to rubber stamp Christine's recommendations, then this was not a fair process. He said the board had followed all required procedures and the hearing was now concluded. I said I wanted to present one more piece of evidence. I pulled out the photo of the snow gauge stake and said Christine had planted this in my yard without permission and moved it multiple times to manufacture violations. I said that was trespassing and tampering, and it showed the whole enforcement campaign was premeditated and targeted. Christine stood up and said the stake was a community monitoring tool and its placement was authorized under the covenant maintenance clause, and my removal of it was theft of HOA property. I said there was no such thing as a community monitoring tool in the covenant I signed, and I had the original document with me if she wanted to compare. She said the covenant had been amended multiple times and the board had the authority to implement safety measures without resident approval. I asked to see the recorded amendments. She said they were filed with the county and available for public review, but she was not required to produce them at the hearing. The board president said the discussion was becoming unproductive and the meeting was adjourned. I said I was not done presenting my evidence. He said I had presented enough and the board would review everything and issue a decision. The other board members started packing up their papers and Christine walked out without looking at me. I stayed in my seat and pulled out my phone. I opened the recording app and replayed the audio I had been capturing since the start of the meeting. I said out loud, for the record, the board refused to let me present all my evidence. The chair made false claims about covenant authority, and the process was not fair or transparent. The board member in the back row, the one pretending to be neutral, turned around and said recording board meetings without permission was a violation and I needed to delete it immediately. I said the meeting was open to residents and I had a right to document what was said. He said the board had a policy against recordings and I was in violation. I said, "Show me the policy." He did not respond. I saved the recording, put my phone away, and walked out. If you are enjoying this HOA chaos, hit that like button and subscribe, because it only gets worse from here. The next morning I got an email from the management company saying the board had reviewed my submissions and determined the violations were valid and the fines were enforceable. The email said I had 5 business days to pay the full amount of $1,200 or the board would proceed with lien filing and report the delinquency to the county. The email also said my recording of the hearing was a violation of board policy, and I was being assessed an additional $100 administrative fee for disrupting the process. I forwarded the email to Angela and called her immediately. She said this is exactly what we expected. They are trying to bury you in fees and hope you give up. She said she would file the motion to block the lien that afternoon and request an emergency hearing to challenge the validity of the fees and the board's authority. She said we would also file a formal complaint with the county about the inspection practices and the lack of recorded amendments, and if we found evidence the board was operating outside the covenant, we could potentially void the entire enforcement action. I asked her how long the process would take. She said the motion would be heard within 2 weeks if we got lucky, longer if the court was backlogged. She said in the meantime I should not pay anything, do not sign anything, and document every contact with the board or the management company. She said if they try to place the lien before the hearing we would file an emergency petition to stop it, and ask the court to sanction the board for proceeding during active litigation. I said okay, and I asked her what I should do if Christine or the board tried to escalate again before the hearing. She said ignore them, do not engage, and if they come on your property or send vendors without consent, call the police and file a report. She said we need a paper trail showing they are acting in bad faith, and every misstep they make strengthens our case. That weekend I was sitting in my living room when I heard a truck pull up outside. I looked out the window and saw a contractor vehicle with a decal for a towing and immobilization service, and a guy in a reflective vest was walking toward my driveway carrying a wheel clamp. I ran outside and said, "What are you doing?" He said he had a work order to immobilize a vehicle at this address for unpaid HOA fees and safety violations. I said, "You cannot do that, the fees are under dispute, and my attorney is filing a motion to block enforcement." He said he was just following the work order and he had authorization from the board. I said, "Show me the work order." He pulled out a printed page with Christine Howard's name typed at the bottom and the board logo, no readable signatures, and the work order said immobilize vehicle pending resolution of delinquent account, authorized under emergency compliance powers. I said there is no such thing as emergency compliance powers, and if you put that clamp on my car, I am calling the police. He said he did not want any trouble and he was going to call his supervisor. He pulled out his phone and dialed, then put it on speaker. A man's voice answered and said, "This is Dave, what is going on?" The contractor said, "I am at the Preserve at Frostwood address and the resident is refusing to allow the immobilization. Says the fees are under dispute and he has a lawyer." Dave said, "Hold on. Let me check the file." There was a pause. Then Dave said, "Who authorized this work order?" The contractor said, "It is signed by Christine Howard from the board." Dave said, "I do not have any record of this being approved through our normal process. This looks like it was sent directly from the HOA without going through dispatch, and I am not comfortable proceeding without verifying it is legitimate." He said, "Tell the resident we are canceling the job, and we will contact the HOA to confirm authorization before we come back." The contractor said, "Copy that," and he hung up. He looked at me and said, "Sorry for the confusion, we are not doing anything today." He got back in his truck and left. I stood there shaking, partly from cold and partly from adrenaline, and pulled out my phone to call Angela. She did not answer, so I left a voicemail explaining what just happened, and said I wanted to file a police report for attempted illegal vehicle immobilization. 5 minutes later, Christine walked up my driveway. She was wearing her white parka and gray knit hat and holding the laminated policy sheet. She said the contractor was here under board authority, and your obstruction is going to cost you another $500 in enforcement fees. I said, "You do not have the authority to immobilize my car. The covenant does not allow it, and your own vendor just confirmed the work order was not legitimate." She said the board has emergency powers during winter safety crises and we can take any measures necessary to compel compliance. I said, "Show me where in the covenant it says that." She held up the laminated sheet and said, "It is all here, and if you had bothered to read it instead of fighting every single thing, maybe you would not be in this mess." I said, "Let me see it." She pulled it back and said, "I do not hand this to residents who have proven they will twist the language and waste everyone's time." I said, "You keep talking about amendments and emergency powers, but you have never produced a single recorded document, and my attorney is going to subpoena the county records and prove you are making this up." She said, "Good luck with that. The board has been operating under these rules for 5 years and no one has ever challenged them successfully." I said, "There is a first time for everything, and you just tried to have my car booted based on a fake work order. So I am pretty sure a judge is going to be interested in that." She stepped closer and said, "I am the reason this neighborhood stays civilized, and people like you who think the rules do not apply are exactly why we have to be strict." She said, "You moved in 2 months ago, and you have already caused more problems than residents who have been here for years. And if you do not start showing some respect for this community, you are going to find out what happens when the board stops being patient." I said, "The board has not been patient. The board has been harassing me with fake fees and fake inspections since day one, and I have proof of all of it." She said, "Your proof is not going to matter when the lien is filed and you lose your home." I said, "The lien is not getting filed because my attorney is blocking it, and when we get in front of a judge you are going to have to explain why you planted a monitoring stake in my yard, why you posted a smear campaign from the board office, and why you just tried to boot my car without legal authority." She said, "You are going to regret this," and she turned around and walked away. I went inside and called Angela again. This time she picked up. I told her what just happened with the contractor and Christine's visit. She said, "This is escalating fast and we need to get ahead of it." She said she would amend the motion to include the attempted vehicle immobilization and request an emergency restraining order to prevent the board from taking any further enforcement actions until the court ruled on the fees. She said she would also send a letter to the towing company informing them that any future attempts to immobilize my vehicle would be considered illegal and subject to criminal and civil penalties. She said I should file a police report right now documenting the contractor visit and Christine's threats, and we would attach the report to the motion as evidence of ongoing harassment. I drove to the police station and filed the report. The officer who took my statement said HOA disputes were usually civil matters, but the attempted vehicle immobilization could be considered harassment or trespassing depending on the circumstances. He said he would document everything, and if the board or the contractor came back, I should call 911 immediately and request an officer on scene. He gave me an incident number and said keep copies of everything. I went home and updated my file with the incident number, the recording of the contractor supervisor canceling the job, and photos of Christine standing in my driveway during the confrontation. I also checked the neighborhood group chat and saw a new post from the same anonymous account, this time saying resident continues to obstruct safety measures, board forced to escalate enforcement, community members advised to avoid interaction and report concerns to compliance chair. I screenshot the post and sent it to Derek. He called me and said the metadata matched the previous post, same IP address, same upload pattern, definitely Christine. He said he could generate a second report showing both posts came from the same source and the timestamps proved a coordinated campaign. I said do it, and send it to Angela so she can add it to the motion. The next day, Angela filed the amended motion with the court. She sent me a copy, and it was 20 pages long, including exhibits with the payment records, the metadata reports, the photos of the notices, the contractor work order, the police report, and transcripts of Christine's texts and emails. The motion asked the court to block the lien, void all fees, issue a temporary restraining order preventing further enforcement, and award damages for defamation and abuse of process. She said the hearing was scheduled for the following Wednesday and I needed to be there to testify if the judge asked questions. She said the board would probably bring their attorney and try to argue the covenant gave them broad powers, but we had enough evidence to show they were operating in bad faith and the fees were punitive. She said if we won the motion, it would not only stop the lien, but it could also trigger an investigation into the board's practices and potentially lead to sanctions or removal of board members. I asked her what the chances were. She said based on what we have, I would say 70% in our favor, maybe higher if the judge is familiar with HOA abuse cases. She said the biggest risk is if the board produces recorded amendments that actually grant them the powers they are claiming, but even then we can argue the amendments were not properly disclosed to residents and the enforcement was retaliatory. That weekend the weather turned even worse. The freezing fog came back, the plow was scheduled to come through on Monday, and Christine was using that as leverage to trap me. She sent a mass email to the neighborhood saying the plow would not service driveways that had unapproved snow storage or obstructed access, and residents who failed to clear violations by Sunday night would be skipped and assessed a missed service fee of $200. I replied to the email and said the plow is a community service paid for by HOA dues, and the board cannot selectively deny access based on fabricated violations. She replied and said the plow contractor had the right to refuse service if safety conditions were not met, and my driveway was flagged as non-compliant. I forwarded the exchange to Angela and said this is retaliation for the motion. Angela said agreed, and we will add it to the evidence. She said if the plow skips your driveway on Monday, take photos and document it, and we will use it to show the board is continuing to harass you during active litigation. She said that could push the judge to grant the restraining order immediately instead of waiting for a full hearing. Monday morning the plow came through. I stood at my window and watched as the truck cleared every driveway on my street except mine. The driver slowed down when he got to my house, looked at a clipboard and kept going. I ran outside and flagged him down. He stopped and rolled down his window. I said, "Why did you skip my driveway?" He said, "I have you marked as non-compliant. Board says to skip." I said, "Who told you that?" He said the compliance chair sent the list this morning. I asked to see the list. He showed me a printed page with my address circled in red and a note that said snow storage violation. Do not service until cleared by board. I took a photo and said this is retaliation and I am reporting it. He said I am just doing what I was told, take it up with the board. He drove off and left a wall of snow at the end of my driveway twice as high as anyone else's. I spent 2 hours shoveling the snow myself, my back screaming and my hands numb, and by the time I was done I was so angry I could barely think straight. I called Angela and told her what happened. She said, "Perfect, we now have direct evidence of retaliation and selective enforcement, and I am filing an emergency petition for the restraining order today." She said the judge will see this and know the board is acting in bad faith, and it will make our case even stronger. She filed the petition that afternoon and requested an expedited hearing. The court scheduled it for Tuesday morning, 1 day before the main motion hearing. Angela said this is good. If we get the restraining order first, it will freeze the board's ability to do anything else while we fight the fees, and it will send a message that the court is taking this seriously. Tuesday morning I met Angela at the courthouse. The board's attorney was there, a man in his 50s in a suit, and he was talking to Christine in the hallway. Christine saw me and glared but did not say anything. We went into the courtroom and the judge, a woman in her 40s, called the case. Angela presented the petition and walked the judge through the timeline, the fees, the inspections, the smear campaign, the attempted vehicle immobilization, and the plow retaliation. She submitted the exhibits and said the board was engaged in a targeted harassment campaign against my client, and the pattern of escalation showed they would continue unless the court intervened. The board's attorney argued the board was exercising legitimate enforcement powers under the covenant, and my refusal to comply was forcing them to take stronger measures. He said the fees were justified, the inspections were authorized, and the plow decision was a safety call made by the contractor, not the board. He said there was no evidence of bad faith, and the petition should be denied. The judge asked if the board had any recorded amendments granting them emergency powers or the authority to conduct inspections without notice. The attorney said the amendments were filed with the county and he could provide copies. The judge said provide them now, or I am not considering them. He shuffled through his papers and said he did not have them with him, but he could get them by tomorrow. The judge said that is not good enough. You are asking me to deny a restraining order based on authority you cannot prove exists. She looked at Angela and said, "Does your client have the original covenant he signed?" Angela said yes, and we have confirmed with the county that no amendments affecting enforcement powers have been recorded since 2015. The judge said so the board is claiming powers that do not exist in the recorded documents. The attorney said the amendments exist, they just have not been re-recorded because the board was not required to do so under state law. The judge said actually under Minnesota law any amendment that materially affects enforcement or assessment authority must be recorded to be enforceable against residents, so if your amendments are not recorded they are not valid. She said based on the evidence presented I am granting the temporary restraining order. She said the board is prohibited from assessing any new fees, conducting any inspections, contacting the plaintiff except through his attorney, or taking any enforcement actions including lien filing, until the court rules on the validity of the existing fees at tomorrow's hearing. She said if the board violates this order they will be held in contempt and subject to sanctions. She signed the order and handed it to the clerk. Angela thanked the judge and we walked out. Christine and the board attorney were still in the hallway. Christine looked like she wanted to scream, but she just turned and walked away. Angela said that went better than I expected. The judge basically told them their whole enforcement scheme is invalid because the amendments are not recorded. She said tomorrow's hearing is going to be about whether the fees can stand without the amendments, and my guess is the judge is going to void them and possibly order a refund of anything you have already paid. I said I have not paid anything. She said good, keep it that way, and tomorrow we are going to ask the judge to void all the fees, dismiss the lien threat, and award you damages for the harassment. She said bring the incident number from the police report and any other documentation you have, because we are going to bury them. That night I got a call from Derek. He said the neighborhood group chat just exploded. Someone leaked the restraining order and people are asking what is going on. He said Christine posted a response saying the board is defending the community against a resident who refuses to follow basic safety rules, and the legal action is a distraction from the real issue, which is my non-compliance. I said she is still trying to control the narrative even after the judge told her to stop. Derek said yeah, and people are starting to push back. Someone posted asking why the board never disclosed the amendments and why they are not recorded, and Christine has not responded to that yet. He said I think the tide is turning. People are starting to see through her. The next morning, Angela and I went back to the courthouse for the main motion hearing. The board's attorney was there, and this time he had the board president and Christine with him. The judge called the case and said she had reviewed the motion and the exhibits, and she wanted to hear from the board about the legal basis for the fees and the enforcement actions. The attorney stood up and said the board has the authority under the covenant to assess fees for violations and to take measures to ensure compliance. He said the plaintiff repeatedly violated snow storage and noise rules, and the board followed all required procedures including notice and a hearing. He said the fees were reasonable and necessary to protect the community. The judge said, I reviewed the covenant your client provided, and I do not see any provision that allows unannounced inspections or emergency powers or selective plow service. She said, where is that authority coming from? The attorney said it comes from the amendments adopted by the board in 2018 and 2020. The judge said, do you have recorded copies of those amendments? He said no, but we have board meeting minutes showing they were adopted. The judge said meeting minutes are not sufficient. Amendments have to be recorded to be enforceable. She said without recorded amendments you are back to the original covenant, and the original covenant does not support the fees you assessed. She said it looks to me like the board made up rules as they went along and used them to target this resident. The attorney said the board acted in good faith, and the plaintiff's refusal to cooperate escalated the situation. The judge said acting in good faith does not mean you can invent authority you do not have. She said I am voiding all the fees, dismissing the lien threat, and ordering the board to issue a public retraction in the neighborhood communication platform stating that the violations were unfounded and the enforcement was improper. She said I am also ordering the board to refund any fees the plaintiff has already paid, though it appears he has not paid anything, so that is moot. She looked at Angela and said, does your client want to pursue damages? Angela said, yes, Your Honor. We are asking for damages for defamation, harassment, and abuse of process, and we are also asking the court to refer this matter to the county for investigation of the board's practices. The judge said I am awarding the plaintiff $2,000 in damages to cover his attorney fees and the harm caused by the board's actions. She said I am also referring this case to the County Homeowner Association Ombudsman for a compliance review, and I am recommending the board be required to re-record all amendments and provide full disclosure to residents within 90 days or face further sanctions. She said the restraining order remains in place until the board complies with this order, and if there is any further retaliation or harassment the plaintiff can file for an extension, and I will consider additional sanctions including removal of board members. She signed the order and said we are adjourned. Christine stood up and tried to say something, but the board attorney grabbed her arm and pulled her back down. The judge looked at her and said, if you have something to say you can submit it in writing, but this hearing is over. We walked out and Angela said that was a clean sweep, you won on every point. She said the damages cover my fees, and the referral to the county is going to force the board to clean up their act or face state intervention. I asked her what happens next. She said the board has 10 days to comply with the order. That means they have to post the retraction, stop all enforcement, and cooperate with the county review. She said if they do not comply, we file a contempt motion and the judge will bring the hammer down. She said you should also expect the board to try to settle quietly and make this go away, because the last thing they want is the county digging into their finances and practices. I said, what about Christine? Angela said she is done. The judge basically said the board was acting in bad faith, and Christine was the one running the show, so the other board members are going to distance themselves from her fast. She said I would not be surprised if she resigns or gets voted out at the next election, because no one wants to be associated with a board member who cost the HOA $2,000 and triggered a state investigation. That afternoon I got an email from the management company. It said the board had received the court order and they were working on compliance, and they apologized for any inconvenience caused by the enforcement actions. The email said the fees had been removed from my account and the file was closed. It did not mention Christine or the retraction. I forwarded the email to Angela and said they are trying to bury it quietly. She said, yeah, but the judge ordered a public retraction, so they do not get to just send you an email and call it done. She said I am going to follow up with them tomorrow and make sure the retraction gets posted in the neighborhood chat where everyone can see it, because that is part of the order and they do not have a choice. The next day, the retraction appeared in the group chat. It was a short post from the board president saying the board had reviewed the enforcement actions taken against my address and determined the violations were unfounded and the fees were assessed in error. It said the board apologized for the inconvenience and the matter was now resolved. It did not mention Christine by name, but everyone knew who was responsible. The comments started coming in immediately. People were asking why the board never disclosed the amendments, why they assessed fees without legal authority, and why Christine was allowed to run enforcement like a personal vendetta. Someone posted a link to the court order and said the whole thing was a scam and the board owed everyone an explanation. Derek texted me and said, "This is beautiful. Christine is getting roasted and the board is in full damage control mode." He said someone started a petition to recall the entire board and it already has 30 signatures. He said, "You broke the whole system and now people are waking up." I felt a weird mix of relief and exhaustion. I did not raise my voice, because my proof was louder than any argument. I had the timeline, the metadata, the police report, and a lawyer letter that forced a retraction and a refund. Christine's complaint was ruled unfounded with evidence cited, and the HOA sent a correction email retracting the smear. The whole thing fell apart because I kept receipts. 2 weeks later, I got a notice in the mail saying the county ombudsman was conducting a compliance review of the preserve at Frostwood HOA Incorporated, and they wanted to interview residents about their experiences with board enforcement. I filled out the form and submitted it with copies of everything I had. A month after that, the county issued a report finding the board had operated outside its authority, failed to record required amendments, and engaged in selective enforcement that violated state HOA regulations. The report recommended the board be placed under supervision, required to re-record all amendments, and prohibited from assessing fees without written legal opinions confirming the authority. It also recommended Christine Howard be removed from any compliance or enforcement role. The board voted to accept the recommendations, and Christine resigned the same week. The neighborhood group chat had a field day. People were posting about how they had been hit with bogus fees for years and never knew they could fight back. Someone organized a town hall to discuss reforming the board and electing new members who would actually follow the law. I showed up and told my story, and people were shocked at how far Christine had gone and how close I came to losing everything. A few months later, there was a board election. 3 of the old board members did not run for re-election, and the new candidates all campaigned on transparency and following the recorded covenant. I voted for the slate and they won in a landslide. The new board president sent an email saying they were committed to rebuilding trust and making sure enforcement was fair and legal. I also got a check in the mail for $2,000 from the HOA's insurance carrier, the damages the judge awarded. I deposited it and used part of it to pay Angela's remaining fees and the rest to buy a new snowblower so I would never have to shovel by hand again. The iced-over community footbridge, where Christine tried to stage a hazard photo and got caught doing it, became a bit of a legend in the neighborhood. Someone told me a board member had been watching and pretending to be neutral, but later admitted Christine asked him to take photos of me slipping on the ice so she could use them as evidence of my unsafe snow clearing. He refused, and that was part of what turned the board against her when the legal fight started. The small snow gauge stake I pulled out of my yard ended up being mentioned in the county report as an example of invasive monitoring practices. The report said residents have a right to privacy on their property, and the board cannot use surveillance tools or frequent inspections to harass people into compliance. The final twist came about 6 months later. I got a letter from the HOA's insurance carrier saying they were issuing a non-renewal warning to the board because of the compliance violations and the legal settlement. The letter said the carrier would not renew the association's liability coverage unless the board implemented reforms within 60 days, including recorded amendments, written enforcement procedures, and mandatory training for all board members on HOA law. The letter said if the reforms were not completed, the entire neighborhood could lose insurance coverage, and that would trigger a default under most residents' mortgage agreements. The board panicked and held an emergency meeting. They hired a lawyer to draft new bylaws, recorded all the amendments with the county, and sent every board member to a weekend seminar on Minnesota HOA regulations. People in the neighborhood were talking about how close we came to a total meltdown, and how one bad board member almost destroyed the whole association. I just kept my head down, cleared my snow, and stayed out of the drama. I had already fought my fight and won. Looking back, the whole thing was absurd. I moved to St. Paul for a coaching job and cheaper rent, and I ended up in a legal war with a board chair who thought she could invent rules and crush anyone who pushed back. But I kept every email, every text, every notice, and every receipt, and when it mattered, I had proof that made her whole operation fall apart. Christine's stopwatch and ruler routine got mocked by the room during the hearing when someone pointed out she was measuring snow piles to the inch, while the county did not even have regulations for residential snow storage. The board attorney tried to defend it, and the judge just shook her head like she could not believe what she was hearing. I still see Christine around the neighborhood sometimes. She does not make eye contact, and she crosses the street if we are on the same sidewalk. I heard she moved to a condo across town a few months after the resignation. Good riddance. The new board is not perfect, but they follow the rules and they do not weaponize enforcement. I have not had a single violation notice since the election, and my driveway gets plowed with everyone else's. The neighborhood feels different now, less tense, less paranoid, like people can actually live here without waiting for the next bogus fee to drop. I kept the thermos mug I carried through the whole fight. It is scratched and dented from all the frozen mornings standing in my driveway arguing with contractors and board members, but it still works. Every time I use it, I remember that I did not raise my voice, because my proof was louder than any argument. And that is the lesson. When someone with a clipboard and a laminated policy sheet tries to bully you, do not yell, do not quit, just keep receipts and find a lawyer who is not afraid to call them out. The system works if you work it, and sometimes the Karen loses. Thanks for watching, and I will catch you in the next one.